Hi, good morning or good afternoon, whatever time it is right there. Good morning, good afternoon. Hi there, good morning, good afternoon. My name is Kemi Adefarakon, and I'm a lawyer here in Ontario. I focus on wills, contracts, and trademarks. I'm also the founder of Legally Smart CEO, where I help women, business owners start, run, and protect their businesses, their brands, and legacies with confidence. So today we're going to be diving into a big but often avoided question. What happens if you die without a will? I know that this is something that we usually don't like talking about, we avoid a lot, but it doesn't make the reality go away. And so my goal here is really help you understand the truth so you can make wise, loving decisions for you and your family. So what happens when someone dies without a will? The law says that they've died intestate. That means their estate, everything they own and everything they owe, is handled according to the intestacy laws of the province. I live in Canada, so provinces where they live. So the laws vary across Canada, but the result is always the same. The law decides what happens, not you. So let me really break this down for you. When you die without a will, what happens? One, you don't get a choice of estate trustee or executor. That means that without a will, you don't get to decide who manages your estate. Someone like a close relative now has to apply to the court to act as an administrator for your estate. That means that the person has to collect all your assets, pay debts, file taxes, and then only distribute what's left. And then the second thing is no choice of guardianship. If you have minor children, the court decides who raises them. Your family members can apply, but ultimately the judge decides based on what they believe is the best interest of the child. And that might not match your values, your faith, or your wishes. And in the meantime, your children could be placed in temporary foster care. And then the third thing is that there's no say in how your assets are divided. Intestacy laws apply a rigid formula to distribute your assets. They don't consider blended families, stepchildren, or even your personal intentions. And then the fourth thing is that the process becomes more expensive and slower without a will. Where there's no will in place, settling your estate always costs more and takes longer. So, for example, in Ontario, it can actually cost more to apply for the role of an estate administrator when there's no will. That's because the application process for estates without a will is usually more complex, which means that have to pay higher fees to a lawyer or to a paralegal to handle it. And this may also take so much time as well. And there's this, and which brings me to my next point, which means that there's a strain on beneficiaries. For example, if you have minor children, having to wait to be able to pay their tuition, if you have to pay for mortgage and things like that. So there's usually a strain on beneficiaries. So based on what I've just said, let me break it down for you once again. When there's no will, there's no choice of estate trustee or executor. There's no choice of guardianship for your children if you have minor children. No say in how your assets are divided, and the process becomes more expensive and slower because somebody has to go to court to apply to become the administrator of your estate. And in that case, there may even be so many people that turn up in court and say they want to apply as become the administrator of your estate, and then that makes it even longer as well. So now let me just really give you practically what happens in Ontario, how assets are divided. Because when I talk to people, they're really very surprised as to how the assets, what happens in Ontario really. So how is it divided? When someone dies without a will in Ontario, there's a specific formula the law follows, and it doesn't look like what you may have wanted, or it just the law just applies the law. That's just it. So if you're married and have no children, your spouse inherits everything. If you're married and have children, your spouse gets what's called the preferential share, which right now in Ontario is the first 350,000 of the estate. And then whatever is left is divided between your spouse and your children. If you're single but have children, everything goes to your children equally. If you have no spouse and no children, it goes to your parents and then siblings and then distant relatives. And if you have no living relatives, everything goes to the government. So let's take a real example, because I love to really break this down and make it really practical. Suppose your estate is worth 500,000 and you pass away leaving a spouse and two children. Your spouse will receive the first 350,000 and that leaves 150,000. That means that the 150,000 gets divided into three shares. One for your spouse and one for each of your children. So your spouse gets another 50,000 and each child receives 50,000. And that may not be what you really intended. And the truth is that I know of a story of a case where a young lady, she died before she had always wanted to get a will done, but she died before she could do that. And she had very clear intentions in her mind that she wanted her children, she wanted to leave a lot of money for her children for education and things like that. And she had worked so hard, she was really working hard, and she had made a lot of money, but then she got sick and then she died. And so her plan was to leave some money for her children for their education and some money for her aging parents as well. But then she died unexpectedly. And so, because there was no will, none of that happened. The law stepped in and applied the formula. Her husband received much more than she intended, and the children received far less, and her parents were left out completely. Now, let me get to where it gets really heartbreaking. A few years later, the husband remarried. This time, having learned from his past experience, he made a will. But in that will, he left most of the estate to his new wife. That means that the money that initially came in from his first wife, the money she wanted for her children and her parents, ended up going almost entirely to another woman. I'm sure you wouldn't have wanted that to happen. That was not the woman's intention at all. So now that's the reality of intestacy. The law applies its formula, but it doesn't consider your wishes, your faith, or your family's unique needs. And sometimes it creates outcomes you never would have chosen. Now, this video is really not to scare you, but it's just to show you why making a will matters. A will isn't about focusing on death, it's about protecting life. It's about making sure that the people you love for are cared for and that your values are honored and your legacy goes where you want it to go to. So if you really found this life helpful, please like and subscribe to my channel. And if you want to share it to somebody who believe really needs this. And till next time, I hope to be back again sharing one of these videos to really help you understand what it means to really protect your legacy, plan well before anything happens. Because really, if you don't think about it now, it may just be too late, and we don't want that. So I'll see you in the next video. Please like and subscribe to my channel. Thank you. I'll see you next time. Bye.